righty. Well, welcome. For those of you that don't know me, I'm Jonathan Adler. I'm the Johann Verheij Memorial Professor of Law and the director of the Coleman P. Burke Center for Environmental Law here at Case Western Reserve University School of Law. Welcome to today's program, which is sponsored by the Burke Center. It's really a pleasure today to be able to host Richard Lazarus, who's professor at Harvard Law School. First, I wanted to say a tiny bit about the Burke Center, which is sponsoring today's program. The Burke Center was launched a year and a half ago here at the law school with a generous gift from our alum, Coleman P. Burke. We have designed to expand our curricular programs for students in environmental law, their experiential opportunities, as well as programs like this that are designed to further discussion of and education about important environmental law issues. We had originally planned to have Richard come to campus this past spring. Obviously, that was made impossible by intervening events, but we were thrilled when he agreed to come to a webinar on his new book. So without any further ado, I'd like to introduce Richard Lazarus. As I mentioned, he is a professor at Harvard Law School. In fact, he's the Howard and Catherine Abel Professor of Law, where he teaches courses in a range of environmental law subjects, as well as Supreme Court advocacy. He's a veteran of the Justice Department, having worked in both what was then, I guess, the Land and Natural Resources Division and the Solicitor General's Office. He has taught at Washington University in St. Louis, Georgetown University Law Center, and now at the Harvard Law School. His books include The Making of Environmental Law, which I strongly recommend as a history of development of environmental law. Wrote the report for the federal government on the Deepwater Horizon spill, and is the author most recently of the book that is the subject of today's program, The Rule of Five, Making Climate History at the Supreme Court. You can see the cover pictured behind Richard. I'll include links for the book as well in the chat for today's program, since we can't have a offer the book for sale after the program here. And for those of you joining for CLE purposes, I will put the information about the evaluation form in the chat for today's program, and we will display the code for the CLE program at the end of Richard's lecture. But without any further ado, you didn't come to listen to me. I'm happy to turn things over to Richard, who is going to get his slides started, and then we will be off. Richard?
I think we're all set. Showing, Jonathan?
Yes.
Yes.
Terrific. All right, I'm delighted to participate in this live stream event sponsored by the Burke Center at Case Western University School of Law. I'm really grateful to Jonathan, Professor Jonathan Adler, for this invitation. I hope, as he knows, I've long been a fan. Professor Adler, he is a fabulous scholar, rigorous, very thoughtful, with a very important voice in environmental law across the country. So as Jonathan said, I'm here to talk about a recently published book, The Rule of Five, Making Climate History at the Supreme Court. I'm going to divide my talk into three parts, and I'm really looking forward after that to the Q&A. First, I'm going to describe the arc of the story, my overall goal in writing the book. Then I want to highlight parts of the book story, provide you the sense of the book's voice, what makes the story so engaging and fun, but also I want to reserve some surprises, so you still have to read the book after the talk is over. And third, I want to describe an unanticipated challenge I had in writing the book, and then how I chose to address that. All right, so the book's arc and its primary objective. As you can see, the book is divided into 20 chapters, followed by an epilogue. And the arc literally begins with a guy named Joe, and the story ends with the Supreme Court ruling that made history. The most important environmental law case ever decided by the Supreme Court, Massachusetts versus EPA, often referred to as environmental law's Brown v. Board of Education, a case which not only transformed U.S. climate change law, but had worldwide impact. Now, my primary objectives in writing this book were twofold. First, unlike the other books I've written, I wanted to write a book for a popular audience here, a book that revealed what makes Supreme Court advocacy so challenging and so fascinating, and from both sides of the lectern, where the advocate stands in front of the lectern before the justices, then the other side, within the court itself, what happens in the chambers after the argument is over. I also wanted to open a window to let the general public see inside the extraordinary amount of strategy maneuvering, conflict, the personal and professional drama in Supreme Court litigation, not from bad motives, but just because the stakes are so high. I also then wanted to write a book for a general audience that revealed what's made it so difficult for our country to address climate change, why it's proven so hard, often for reasons people don't know or appreciate, and for why that same reason this case was so important. There's no more important environmental issue facing the world right now than climate change, and the coronavirus underscores there's no escaping the need for global cooperation when you have these kinds of global threats. So I began researching this book in 2015, 2016. I really wrote it in 2018, 2019. This shows you just some of the papers. I approached the research for this book the way I would a Supreme Court brief. I've done about 40 cases before the court, 14 arguments, scorched earth research. I interviewed everybody, Clinton administration, Bush administration people, industry people, people at the states, people in environmental groups, lawyers on both sides. I interviewed judges, I interviewed justices. I also saw all their underlying documents. I ended up knowing far more about this case than any of the participants did. Public record requests, but also just voluntary. People gave me boxes and boxes and boxes of archival material. And of course, given the times we're in, jump drives after jump drives as well. All right, so here are a few highlights from the book and illustrative parts of the story. Beginning, of course, with chapter 1, opening scene. It's October 1999. After a year delay, Joe Mendelsohn walks from his Capitol office. He goes down to EPA and hand delivers a petition demanding that the Clinton EPA regulate greenhouse gases from motor vehicles. Joe, by then, was just fed up. He's fed up by the lack of action by the Clinton administration on climate. So who was Joe Mendelsohn? He was a young public interest lawyer who worked for a public interest organization no one has ever heard of, the Center for Technology Assessment. Had a total of 5 employees, full and part-time. They worked paycheck to paycheck, and more often than not, for no paycheck at all. They had small offices on Capitol Hill, at which they actually been evicted right before the petition was filed for violating local zoning ordinances for having a business and a residence. And Joe worked very much alone. He worked on the petition late at night by his daughter's crib. None of the powerful national environmental groups like NRDC, Sierra Club, Earth Justice supported what he was doing. In fact, some of them during this litigation actively opposed him, even tried at one point to cut off the funding, the only funder they had for their center, because they thought what he was doing was misguided and a bad idea. But Joe refused to bend. He filed his petition demanding the EPA act. His feeling was, you're not my bosses. You can't tell me what to do. I don't have all the resources and trapping and fancy offices that you all have. But I also don't have bureaucracy. I'm my own boss. I can decide whether we're going to file this thing or not. It took him a year to decide. He actually finished the draft in October 98, stuck it in a desk drawer, and took a year to take it out, waiting for the right time, partly because all the pressure he was in not to do it. He pulled the trigger, he walked down to EPA, hand filed it. He actually sent a copy to Al Gore for good measure, because he was so furious at Al Gore for not doing anything on climate during these 7 years of the Clinton presidency. The petition made its way to its docket room, where it was formally received. It was by a docket clerk there named Jamie Poole. She signed it, she dated it, she put it in a cart, and that cart went down the hallway, actually walked the hallway from the docket room to EPA General Counsel's office. No one then imagined that 8 years later, that petition would arrive in the United States Supreme Court. And what's interesting with historical perspectives, realize there was at first reason to think that EPA might grant that petition, but not the Clinton administration. They sat on it. They referred to it as the turd. They sat on it and they did nothing with it. It was the Bush administration who might well have granted it. Because when the Bush administration took office in January 2001, the Bush cabinet included a series of people who were there as climate hawks. They felt very strongly addressing the climate issue. And part of the reason they were there was because George Bush campaigned in 2000 that he would regulate greenhouse gas emissions, unlike the Clinton administration, which hadn't. Christine Todd Whitman, top left, former governor of New Jersey, she took the job because she was a strong believer in regulating greenhouse gas emissions for climate change. Head of EPA, a person of National stature. No one has been of such national stature head of EPA since Christine Togwin, before or since. Secretary of State Colin Powell, also a climate hawk. He asked for a briefing on climate change within a week of taking office. Condoleezza Rice, then National Security Advisor, same. Paul O'Neill, bottom right, Secretary of Treasury. Paul O'Neill felt so strongly about the climate issue. Before the first cabinet meeting held at the White House, he went early, walked into the room, and put on the desk, on the table in front of everybody, cabinet member's chair, a copy of a speech he gave a year before then, comparing the threat of climate change to nuclear holocaust. So they thought they were going to move on it. And then they were all kneecapped by this guy. Dick Cheney, who was known as the angler for good reason, he outmaneuvered them all. With any consultation with the EPA, any consultation with others who all made clear how important they thought this issue was, he got the President of the United States, George Bush, to renege on his campaign promise in early February of 2001, and to say he would not do it, and to send a letter back to Congress saying not only did he not going to regulate greenhouse gas emissions, but the EPA lacked authority under the Clean Air Act to do so. The President of the United States, without talking to EPA, announced the meaning of the statute administered by EPA. But he is the president, so he can do that. They then denied Joe's petition on September 2003. By the time Joe's case reached the courts, first the DC Circuit, long before the US Supreme Court, Joe was no longer alone. Now there were hundreds of lawyers on his side. Everyone realized this was going to be the case. About a dozen states and more than 24 environmental organizations, public health organizations. And they called themselves the carbon dioxide warriors. When they lost that first round in the DC Circuit in a splintered opinion, but they lost by a vote of 2-1, every one of those dozens of lawyers, about 50 or 60 in total, thought they should walk away from the case, end the case there, and not take it any further. They should lick their wounds. They hadn't lost that much. They should wait for another case, another opportunity, perhaps out in California. Only one of those attorneys out of those dozens thought they should seek further review, including the Supreme Court. And that was this guy, Jim Milkey. Jim Milkey was the counsel of record for the case because Massachusetts was the first one, but he was the lead career attorney in the Environment Division of the Mass Attorney General's office. And Milkey thought they should roll the dice. They shouldn't acquiesce in the loss. They should take a chance. The others said, terrible idea. If they took it further, they'd risk a major loss, a huge setback. They put enormous pressure on him not to file. They called his boss, Attorney General Riley of Massachusetts, and they called Milkey on the phone. Heads of powerful environmental groups called him on the phone. They said, if you do this, the future of the environmental movement is on your head if you take this case any further. But he did. He decided to go further. He decided to seek Supreme Court review because they couldn't stop him. And once he filed a petition, they all joined the petition, not because they thought it was a good idea, not because they thought it would ever be granted, because they wanted to control it and what it said. And then no one could believe it when on June 26, 2006, the Supreme Court granted review. And for those of you who are lawyers, there are a couple other interesting cases granted that same day, quite famous cases. The Lilly Ledbetter case and the Twombly case for you civil procedure gurus. They granted the case and people were stunned. They couldn't believe the court had granted it. It was the first time the Supreme Court had granted a petition over the federal government's opposition on behalf of environmentalists since 1971. Sierra Clumpy Morton, which the environmentalists then lost on standing. So it was amazing they granted, but as they were celebrating, Milkey, who was the one who recently did it, thought to himself, oh my God, what have we done? Because he realized they could lose this case. If they lost this case, it would literally be on his head. Fast forwarding to the lure of the lectern, this is chapter 12. So over the summer of 2006, they did the briefs in the case. The states and environmental groups. They did one joint brief. A fabulous brief, principally authored by Lisa Heinzling, a terrific professor at Georgetown University Law Center, who really wrote a masterful brief. She also wrote a masterful cert petition in the case, which is really why the court granted cert in this granted review in this really otherwise impossible case. But as soon as review was granted, she worked on the brief, and as soon as the brief was filed in late August, early September 2006, then up came from the surface a battle royale over who would do the oral argument in the case. Everyone agreed on one thing. The best person should do the argument, and they should give the best argument. That part was easy. But in the Supreme Court, unlike in the lower courts, the Supreme Court really only allows one lawyer per side, no matter how many people are on that side. In this case, there were like 30 to 40 parties on the side and about 100 lawyers. But the Supreme Court says one, unlike the lower courts, only one can do it. And there was huge disagreement about who that should be. After all was said and done, it came down to two people. The state attorney generals, they favored one, and the environmental groups favored another. It was a good faith disagreement. There were two strong candidates, and it's not unusual in Supreme Court law, and Jonathan would know this, to have these kinds of conflicts when the court only allows one. And the stakes are high, the emotions, the competing egos and ambitions are high. With that said, I've seen these kinds of disputes all the time. In this instance, the oral argument conflict was extraordinarily destructive, more than I've probably seen in any other case. I've seen a lot of fights, but not ones as intense as this one. In fact, it was so intense that 14 years later, it was 14 years ago almost exactly, in October 2006, they fought over who should do the oral argument in the case, that the parties involved, the lawyers, are still not speaking to each other 14 years later. And they were all, many of them were close friends beforehand. Even after it was seemingly settled that Jim Milkey, the state's choice, would present the oral argument, he prepared for weeks and weeks, done practice after practice. Just a few days, about 7 days before the oral argument, the environmental groups called Jim Milkey on the phone and they attempted a coup to basically get him out of the case. They said, "You're not competent to do this. You're not any good. We need to replace you with someone else who we think will do a better job." Now, I've done a lot of Supreme Court stuff. I prepared attorneys. Let me just tell you, this is crazy. This is a crazy idea. You don't bring in an attorney at the last second in a complicated case, and this was a big case, and have them do it when someone else is preparing. You make your person as good as possible. You don't bring in a new person at the last second. It's a crazy idea, but its craziness underscores the depth of its distrust and the degree, the total degree of fragmentation among the petitioners in this case, the states, the environmental groups. And Milkey heard him out and basically said, that's not going to happen. And it didn't. The next several chapters describe the oral argument in the case. They're designed to give the reader a sense of the stunning physical setting of the courtroom. If you haven't been, you should go when they open back up, which hopefully will be fairly soon. The extraordinary give and take between the justices and the advocates, but also between the justices. And here's what a lot of people don't realize. The oral argument is the first time the justices talk to each other about what they think of the merits of the case. By tradition, they don't talk beforehand. They don't talk about it. They wait till the oral argument. And the oral argument, which is an hour long for both sides total, is the longest time they're ever likely to discuss this together and actually discuss it through the advocate. The advocate asks questions, has to answer questions, but the justices are really forecasting their views and lobbying their colleagues. The oral advocate's opportunity is unbelievable. They get to be there when the justices are having that conversation, and they're the point person, they're the pivot person. But the challenge is considerable. They have to decide how to frame the issue in the way most likely to win the case. Makes a huge difference. You frame it one way, you can lose quickly. You frame it one other way, you actually might find a way to count to 5. That's why it's a rule of 5. Justice Brennan coined it. How do you get to 5 votes? Because that's what it takes to get a majority in the Supreme Court. You have to anticipate all the hard questions and develop crisp answers. These days, and back then too, you get, if you're counsel, in 30 minutes, you get 50 to 75 questions. Do the math. The questions themselves take time to ask. Your answers have to be incredibly efficient, very crisp. Yes, no answer, support, transition back. Yes, no answer, support, transition back. It's the justices' questions are the lawyer's equivalent of hitting a Major League Baseball pitch. Try to hit Kershaw last night. That's what it's like to try to answer these questions. And these justices are very smart. They're very good lawyers. The book describes their argument in details. Milky's back and forth with Justice Scalia in particular and the Chief Justice. Justice Scalia asked him 23 questions alone during the oral argument. I'm going to play you a snippet from the oral argument so you can see how Milky chose to frame the case, frame the issue to the justices. And when I start doing the sound, Jonathan, you give me a thumbs up. I'll know the sound is coming through. Here we go. Listen carefully to how Milky does the argument.
Mr. Milky.
Mr. Chief Justice, and may it please the Court, if I may, I'd like to frame the merits very quickly and then turn immediately to standing. Although the case before you arises in an important policy area, it turns on ordinary principles of statutory interpretation and administrative law. EPA made a decision based on two grounds, both of which constitute plain errors of law reviewable under any standard. You're not asking the Court to pass judgment on the science of climate change or to order EPA to set emission standards. We simply want EPA to revisit the rulemaking petition based on permissible considerations.
We simply want EPA to visit the rulemaking petition based on permissible considerations. Now, imagine if you were, as they were there, a climate activist, and you have spent the night on the cold sidewalk outside the Supreme Court on November 28th, so you could be in there for the Supreme Court's first climate change case ever, the biggest issue of our times. And your champion is there. And this is a chance to tell the court why climate change is so important, the catastrophic threats, the existential threats climate change presents, how the government has abdicated its responsibilities to future generations. Let the court know what this is about. And your champion stands up and says, this is just a case about, ordinary principles of administrative law. And yeah, it arises in an important policy area. But it's a pretty simple case, and we just want, you're not asking you to pass judgment on climate. Yeah, you don't order EPA to do anything at all. Just EPA should revisit the petition based on permissible consideration. Right? You listen, you go, this is an outrage. Right? He's throwing the case. What's he doing? Here's the answer. He's being a really good lawyer. The best environmental lawyers are the best lawyers. Milky is not giving a talk to climate activists at a rally. He's not testifying in front of Congress. He's not running for office. He's trying to get 5 votes of 9 justices. And it might make the heart of climate activists go pitter-patter. It might make my heart go pitter-patter to talk about the compelling issue of climate change. But what makes the hearts of Supreme Court justices go pitter-patter is administrative law. This is their bread and butter. What Milky is finding is a way to get to 5. And he knows the way to get to 5 is not to screech and scream and talk about environmentalism, environmental activism, climate. It's to talk about administrative law and to downplay the case. We're not asking for very much, only for a little bit of thing. Why only ask a little bit of thing? Because he's trying to get a win. If he asks for a lot, he's going to lose. So he's going for a win. Now, after the argument is over, 2 days later, the justices all meet in the conference room. And they sit in designated seats. The Chief Justice is in the most senior seat. Across the table, next most senior Justice Stevens, and around it goes. Next most senior Scalia, Kennedy, all the way to Justice Alito, who is then the junior justice, just in his 2nd year. And as a junior justice, his job is to answer the door if someone knocks on it, and take notes. No one else is allowed in the room. No pages, no assistants, no clerks, nothing, just the justices. And they have a design procedure. The chief goes first. He summarizes the case for 2 or 3 minutes, and then he gives his vote. No discussion, no deliberate. He votes. He says what he thinks. And then Stevens goes around. That's why the oral argument's the only time they actually deliberate in any way before they vote. They go around, everyone's waiting for that 5th vote. And they know that 5th vote is there when Justice Kennedy says he's going to vote to reverse the lower court in favor of the environmental groups and the states. It's a 5-4 decision. But it's a vote at conference. It's just tentative. It's not permanent. All the vote at conference does is say, who is the senior justice in the majority, now Stevens, and that justice's job, now Stevens, is to assign the opinion to someone who can keep those 5 votes. Because votes change all the time. It's not a final till 5 justices sign on to an opinion. And they think a lot more hard about it when you actually have writing down to look and debate and discuss. So the senior justice, Stevens, I went down and interviewed Stevens. he had to make a big decision because he knows that Justice Kennedy can wander. And as much as he was going to try to keep Kennedy's vote, the Chief Justice Roberts and Justice Scalia, for the dissenters in two different opinions, they were going to try to lure Kennedy back. And he knows that Kennedy is lureable. He can go different ways. He had done that in environmental cases. So Stevens told me he had a big decision to make, who to assign the opinion to. He really wanted to assign it to himself. It was one of the few big cases of the term where he was actually in the majority, not in dissent. It was the only big case the progressives won that entire term. He wanted it. He also wanted it because he believed strongly in the climate issue. And as a Republican, he was very unhappy that his party was not taking the issue seriously. But he knew if he wanted to maximize the chance to keep the majority, he should give it to the marginal justice, Justice Kennedy. If he assigned the opinion to Kennedy, Kennedy was much less likely to wander. And Stevens told me about how he saw Brennan once make the mistake, keep the opinion for himself, Brennan, and lose Kennedy. And his majority became a dissent in a major civil rights case. But after all was said and done, Stevens decided he'd keep it for himself, but he had to keep Kennedy. So that was his job. He put out the first draft. He got 4 votes total, including his own. And there were 4 dissenters. Second draft, still 4 votes. Third draft, 4 votes. He's trying to get Kennedy's vote. He's giving up things. He's trying to get things on that side. Fourth, 4 votes. Fifth, 4 votes. Around the 6th draft, still 4 votes. At this point, Justice Souter, and none of us knew this before, wrote a separate concurring opinion because he started to be unhappy about some of the compromises being made. And Ruth Bader Ginsburg joined it. Draft 7, still 4 votes. Draft 8, Kennedy signs. It's one reason, if you ever study this case, this opinion, it's hard to outline because it's not the most logically oriented drafted opinion in many ways, but that's what it takes to get your votes. Sometimes you have to be a little unclear in your reasoning to get your votes. Stevens succeeded, and it was an opinion by the court that came out on April 2nd, 2007, written by Justice Stevens. And look at his opening line. It's a call to action. He makes it all about climate change. The petitioners, the environmental groups, had tried to make it just an ad law case to win. But now that the win is there, Stevens writes an opinion like a judge would in the 1970s. It's an activist opinion. It's a call to action. It's the way he wrote it made it more significant than it might otherwise have been. It isn't until the Obama administration happens, though, that the ruling actually makes history. Because the Obama administration takes this ruling, they take an EPA loss in the Bush administration, and they use it as the basis of all the climate regulations they enact during 8 years during the Obama administration. They take a loss for EPA and they turn it into a victory for the Obama administration going forward. It's the opening bell. Because one thing Barack Obama knew, you could not effectively address climate change unless there was an international accord of some kind. It requires no one country can do it. But the rest of the world had showed they were going to do squat of significance until the United States went first. Why? Because the United States was more responsible than any other country in the world for accumulating greenhouse gas emissions in the atmosphere. By this time, China was beating us on an annual basis, but greenhouse gas accumulated over time. And international attempt after international attempt had failed miserably because they wanted to see the US first. And Obama spent 7 years trying to show that the US was all in before they met in Paris in December 2015. And he did every single one of those actions based on mass versus EPA. That's how he proved his case. And that's why this case led to the Paris Accord of December 2015, which otherwise wouldn't have happened. Now, when I started writing this book, as I said, in 2015, that was the end of the story. I knew my story. My story was, Joe Mendelson in the 90s, mass versus EPA, Obama makes history with the case, and away we go. That leads me to my last topic before I talk about answer questions. And that is, I didn't then anticipate how the world would change by the time I was completing this book. I didn't anticipate the results of the 2016 election. Now, maybe if I spent more time in Ohio and less time in Cambridge, Massachusetts, I would have had more of a sense of it. But I'll readily confess I was caught off guard. The question I had as an author was, what should I do with it? And I knew a few things. I knew I had to acknowledge, I couldn't ignore the election. I had to explain its relevance. But I also knew I did not want this book to become yet another book about the Trump presidency, wed to the latest actions and developments of the moment. My goal in this book was to tell a story, an uplifting, inspiring story, which had a half-life long before the current sort of this and that of everyday life. A story meaningful which showed how people could make a difference, how the Supreme Court could make a difference, how good advocacy could make a difference for years, for readers years from now, ranging from seasoned Supreme Court advocates, to high school students. A thrilling story. So that's the role of the epilogue, to place the Trump presidency in some perspective and what lessons the book story has for all of us. So what are those lessons? First, the difference one person can make in making history. There are many different one people in this book, but often one person courageously made a difference. Second, even the most important historic Supreme Court rulings are never enough. It takes more than the votes of 5 justices to have transformative changes in the United States. And it should take the votes of more than 5 justices. Brown v. Board of Education, unbelievable decision, incredible promise. Has it ended race discrimination in the United States? Of course not. It's taken decades. It took actions by Congress, legislation, takes time. Massachusetts EPA, enormous promise. Whether that promise is realized takes more than votes of justices. Truly transformative change requires not votes of justices, but votes of individual citizens. And that's how we get implementing legislation. And that's how it should be. The Supreme Court can jumpstart us, but it can't complete the process. Which is why I'm really pleased to be talking about this book, 2 weeks? Just shy of 2 weeks before an incredibly important election in this nation's history. As I said at the outset, delighted to be here. I'm happy to answer Jonathan's questions, anybody else's. And I'll stop sharing my screen too, so we can see people. Thanks.
Great. Well, thank you, Richard. As mentioned before, we'll be providing the CLE code at the end. There's a Q&A box. Please go ahead and type in your questions. First, a very practical question. The book itself has a wealth of information. You've been showing some interesting documents and stuff. Is there an appendix, or is there a website? If, one of our fellow academics asked, if they wanted some of these documents to show their students and stuff, anywhere they can get them?
There's not, but if they write, I've sent things to people. But I've got, although the book has footnotes, not nearly the same footnotes a law review article was. My draft had everything done, and I had everything double checked, triple checked, and I've got all the sites. I've got PDFs of everything.
Sure. You talk. I mean, part of the story is this inspiring story of a particular attorney, battling the odds, pursuing the cause when everyone says they shouldn't. The book also, I think, talks about, I guess, some failures, right? And I guess as educators in teaching our students, we want to identify people who are successful and identify why they're successful, but also kind of identify mistakes so we can avoid them. Are there one or two? I mean, other than some folks, I guess, thinking his case was going to be harder to win than it turned out to be, are there particular points where you think there are decisions to learn from? I mean, like one that is sometimes suggested is by denying the petition, the Bush administration made it easier to litigate because there was a final agency action.
Yeah, I mean, absolutely. I mean, the fact is, one thing I found out in the book describes, there was a battle within EPA. The career people said, just sit on it. Don't do anything with it. Just sit on it. Don't deny it, because there was no even right to file the petition in the first place. There was no provision of any kind for this petition. They could, and very hard to do anything if they just sat on it. But the fact is, what happened is the career people were overridden, and some of the more pragmatic political people at EPA were overridden. And we had a very aggressive White House. There were people, some political appointees, who really wanted to deny the petition. They wanted to litigate it because they wanted the courts to rule that greenhouse gases were not air pollutants to prevent any future EPA from actually regulating the Clean Air Act. But that decision also meant they were very reluctant to make some of the strongest possible arguments in favor of EPA. And that was that EPA had the discretion to decide that greenhouse gas and air pollution. They want to argue sort of plain meaning. EPA had no choice. That's a much harder argument. So to some extent, they made the case harder than they needed to. And also that kind of interference with really good career lawyering led them to lead to a mistake in how they denied the petition too. And that also led to a loss in the Supreme Court where they could have won it.
One of our participants asks, why did Mendelsohn focus on vehicle emissions? Why not power plants? Why not stationary sources more broadly?
Yeah, great question. So when the Clinton administration isn't doing anything, they did nothing on climate, really amazingly, after Gore wrote the book Earth in the Balance in '92. Lots of other things. There were a series of different pathways chosen, especially in the early Bush years. One was power plants, one was motor vehicles, one was to go, say, their criteria pollutants, different pathways. Mendelsohn chose cars for a basic reason. They were the Center for Technology Assessment. They were really interested in cars. They're interested in new technology and new motor vehicles. They can be more fuel efficient. That's why they focused on it. And then theirs was the petition that got further action sooner, and there's the one that was denied and triggered it. But there was a series of efforts. There was a common law effort, federal common law of nuisance. There are 4 or 5 different litigation initiatives around the country, and Joe's is the one that took off, and they did it because of cars, because they like cars.
So you talked about how it took so long to get Justice Kennedy on board, and we've gotten a bunch of questions from attendees about that. And I guess to crystallize them, what made Justice Kennedy, or what was the issue that was the holdup? And in your view, did Justice Stevens take a risk by stressing climate change so much in the opening of his opinion? And for folks on the call, and Richard has pointed this out elsewhere, in the last 15 years, one of the other things that sticks out about this opinion is it's one of the few environmental law opinions that actually talks about the environment as being a motivating or a particular concern, right? The environmental content of a lot of the Supreme Court's opinions tends to be incidental to the way the justices write the decision. This is very different. From the first line of the case what the outcome is going to be. So both what was Kennedy concerned about? Why was he holding back? And was this a risk by Justice Stevens to emphasize the environmental and policy aspects up front like that?
Yeah, where the give and take really was focused elsewhere.
Okay.
It was focused on the Article 3 standing issue, okay, which actually was the one way the environmental groups couldn't afford to lose this case.
Sure.
That's why many people thought they shouldn't bring it, because they lost on whether or not they had a right to bring a case in federal court based on allegations of injury from climate change. Be game over for all climate change litigation in the U.S. Supreme Court. But that's where it was. Kennedy was someone who had been on different sides of the standing issue in environmental cases. And in candor, which I like to be always, the Supreme Court precedent on Article 3 standing, which requires an imminent concrete injury, redressability, and a causal nexus, it doesn't fit neatly with climate change. I mean, I actually think that climate change clearly should be satisfy Article 3 standing, but I would be the first to admit the way the court has articulated its test, which is the test they fabricated for Article 3, it doesn't fit. It's very hard to say it's concrete imminent. Causal nexus is complicated because climate change happens over decades and centuries. Redressability is hard because any one bit is small and sources all over the world can equally affect. So that was a real risk to lose on Article 3 in this case, and that's where it was. And so what you see when you look at Stevens' opinion in this case It's a really oddly organized opinion, right? He spends the first time first part of the opinion embracing everything Kennedy has ever written about Article 3 standing, with lengthy quotations. And he endorses Kennedy's idea that states may be entitled to special solicitude for standing when they're protecting their sort of sovereignty and their borders and their land in a case like this one. And Stevens takes the opinion that Kennedy referred to in an oral argument, Georgia v. Tennessee Copper, as the reason why they're entitled to it. What's fascinating about that case, and Jonathan knows this, is there are about 40 briefs filed in this case, hundreds of pages, a lot of an article you're saying no one cited Georgia v. Tennessee Copper. No one cited. No one actually thought it was on point because of another case after that, Massachusetts versus Mellon. The environmental groups hadn't cited. They'd actually thought about it in the DC Circuit and had, not this case, but this line of precedent, they hadn't done it. And an oral argument, it comes up, Kennedy raises it. And Jim Wilkie told me when Kennedy said, what about Georgia v. Tennessee Copper? Isn't that your best case? Wilkie told me he thought, I've never heard of that case, but if it's good enough for Justice Kennedy, it's good enough for me. And so Stevens wrapped himself around that case too. But then he does it awkwardly. He does all this stuff to get Kennedy, and then he goes, with these things in mind, he then writes an opinion which looks like it's a normal standing opinion. So you try to outline this reason, it doesn't work. You try to get 5 votes, it works. So it's really about standing. I have no sense that Stevens ever had to do any compromises at all on the facts and the opening. And Stevens told me that when he became a Seventh Circuit judge, he learned from one of his colleagues there, the single most important thing to him is the factual statement up front. It's telling the story. I can't remember offhand, I didn't have in the book either, the name of the judge who was his mentor when he was a young judge on the Seventh Circuit. But he said he learned from that judge. And he always spent time on that, and the opening was very important to him. I don't have the sense there was any compromising there.
And in terms, you mentioned there are a lot of briefs. As I recall, there are briefs by business groups on both sides, groups of scientists, and so on. In terms of other than the primary petitioner's brief, were there particular briefs that you think were particularly influential, perhaps even in terms of laying out the factual record or the scientific evidence in a way that was particularly influential to Stevens?
Yes and no. I should say no and yes. I have no sense that any of the amicus briefs, there were fabulous briefs filed by the parties in this case. You have the United States, you have the leading members of the bar, Supreme Court bar on the respondent side, an excellent brief written, championed mostly by Lisa. So I think on the judgment, no effect at all, reversed or affirmed. But amicus briefs do play a role in opinion writing, in how the opinion is written. That's more often where you see the clerks and the justices look. And in this case, there was a brief filed by climate scientists in the case. And I think they even refer to the brief in the opinion. And I think that brief helped write the statement of facts. And that brief helped buttress the standing arguments in the opinion.
We're in the midst of a Supreme Court confirmation process, fight, whatever we call it.
I heard about that.
And climate's come up. So a couple of questions, I guess, related to that. Is Massachusetts versus EPA in danger? Is this something that you think the court might overturn, or in part or in whole, or in what way?
And to answer that question, you really have to look at the different parts of Massachusetts versus EPA. There are really 3 parts. There's the Article 3 standing part, the climate injury is enough. There's the question whether greenhouse gas or air pollutants or not, the meaning of the Clean Air Act. And then there's this question of administrative law about whether EPA abuses discretion in deciding not to decide this petition, a really rarefied question of administrative law. So you look at all 3 parts. On the core part, the part that was most important as a practical matter to the environmental groups, and that's whether greenhouse gas or air pollutants and the Clean Air Act, they're not going to overrule that. The Supreme Court doesn't overrule sort of questions of statutory construction. They don't. If they think they're wrong, they figure Congress's job is to redo it. The only time they ever do it is if the court has invented some crazy thing. It's not in the language. That didn't happen here. So that part of Massachusetts EPA is airtight, not to be overruled. The part that's more vulnerable is the standing issue. because that's a question of constitutional law. It is one thing that Chief Justice Roberts, who's otherwise been the moderating force, he's a hawk on this. He cares deeply about it. He wrote the dissent on Article 3 here. In a case after this called AP versus Connecticut, the same 4 justices made it clear they thought there wasn't standing, so they weren't just genuflecting in front of a prior precedent. So on that one, I think it is vulnerable. They won't overrule it. That's not the chief's style, but they'll seriously erode it if they're given a case. And there's a case out there. There's a case called Giuliani versus United States, and it's a case which is more far-reaching by far than Master versus EPA and the kind of standing arguments they make. If that case ends up before the United States Supreme Court, I think that'll be like raw meat for the conservatives on the court. You don't have Kennedy there anymore, even. You've got, I think, a clear majority to cut back. On the last issue about deciding not to decide, the administrative law one, they won't overrule it because no one's actually followed it since. It's not even clear that it was the better reasoned argument. It's sort of a more sui generis part of the opinion.
Well, I guess related to that, and what do you think the likelihood, I guess, is that the standing parts of Massachusetts versus EPA get eroded in some other context? So, for example, a case the court will hear next month involving the Affordable Care Act also involves a fairly aggressive assertion of authority or of standing by the plaintiff states. Do you think that something like that might be a way the court?
I do. That, I mean, that it's, those kinds of standing issues are very important to the chief, and he is probably the least conservative member of what may soon be a 6 conservative justice majority on the court, and he's very conservative on that issue. So whatever context it comes up, and as we know, it's a cross-cutting issue. It doesn't have to be an environmental case. Whatever the court says in one case can have salience in another case that raises standing.
So when Justice Kennedy was on the court, and I'm pretty sure I got the statistic from you, he only dissented once in an environmental case. Is that correct?
Yeah.
So
versus EPA.
So basically, if you had an environmental case, if you had Kennedy, you were in good shape. And to be frank, that was true for most areas of law, but environment only one. At least looking at the court environmentally, if you're thinking about advocates on either side of various issues, where should they be pitching their cases? How should they be thinking about framing their cases?
Right.
If in the past they could say, pitch to Justice Kennedy, if you got him, you've got it.
Yeah, it's more complicated than people realize. That's why I talk about framing. The justices, they really don't vote like partisans. They're not Democrats and Republicans. They have leanings and tendencies and the issues they care more or less about. So you have to look at them. Right now, if I'm pitching a case, I'm pitching text. I'm pitching plain meaning. So for instance, in 1994, I had a case in front of the Supreme Court, a big environmental case involving the scope of a federal hazardous waste law. I won the case. Who wrote the opinion for me? Justice Scalia. Who was in dissent? Justice John Paul Stevens. I had another case involving asbestos workers and whether you can recover for reasonable fear of cancer. Who is my majority? Opinion written by Ruth Bader Ginsburg, joined by Stevens and Souter. I need 2 more, Scalia and Thomas. The dissenters were the entire middle of the court. The justices are more complicated than people realize. They're not knee-jerk. They're not thinking, I'm against environmental protection, I'm for environmental protection. What's the Republican platform say? What's the Democratic platform say? What does AOC think? They really look at these issues that cut across all the cases, like standing. And you have to figure out what's the way that you can try to get to 5. Or if you're not going to get to 5, what's the way to lose the case that does the least damage? It's called a soft landing, which one also spends a lot of time doing. But framing is everything. And we have a 6-justice majority. I'm not going to be looking for cases to take to the court. But if we're there, I'm not going to assume it's a lost cause. Last term, in a case you know about, the County of Maui versus Hawaii Wildlife Federation case, huge Clean Water Act case. The court clearly took the case to rule against the environmental group, Hawaii Wildlife Fund. But they ruled in favor. By a vote of 6-3, they voted in favor, with Chief Justice Roberts and Justice Kavanaugh joining the majority in a very big win for a broader scope of the Clean Water Act than industry wanted or the Trump EPA wanted. When the Atlantic Coast Pipeline won big case this past term, allowing to go under the Appalachian Trail, right? Justice Thomas writes the opinion. Who joins it? Ruth Bader Ginsburg. You know, these are actually people who listen to legal arguments. So I never surrender a vote. I never assume it. I always think there's a way I can fight for it.
I guess a good example that in an area that could be of increasing importance in environmental law, there was that preemption case, Virginia uranium, from I guess 2 terms ago, where the court was 3-3-3, and the most conservative and most liberal justices were on the anti-preemption side for very different reasons. And then I guess it was Roberts, Breyer, and Alito were the ones supporting the business group's arguments for preemption.
Well, or just this past term, there was a big Superfund case before the court.
Right.
And the big dissents who would have given a complete win to the environmental groups were Thomas and Alito. They would have done it. Federalism preemption is a great example of something which cuts in different directions. And one has to just think about the justices along those cross-cutting issues, and not just assume you know them because you know the politics of the party that put them in power. They're more interesting than that. I wish they were more interesting still, but they're more interesting than people's stereotypes.
So do you have thoughts on the there's a climate case before the court this term that turns on a procedural issue, but it is a climate case involving, I guess, city of Baltimore and a fight between the plaintiffs and the oil company defendants about removal doctrine. Is that an important climate case? Is it a little just civil procedure fight? What's your view of that?
Well, it'll have practical effects for the climate litigation currently all over the country. There are these lawsuits brought all over the country by cities and counties against the energy industry based on state common law of nuisance. And they want them in state court, the plaintiffs, and the defendants want it in federal court, and they want to try to get them dismissed as saying that it's preempted by federal law or displaced by the federal common law. It's really not state law at all. So it's a case which has implications for significant climate litigation, but the legal issue is just a good old federal courts question. And this is why I always tell my students, I doubt you tell your students, Jonathan, the same, and that is, if what you want to do is you care about the environment, you better be a damn good lawyer in every possible area, because it's not often it's a civil procedure issue, a fed courts issue, a tax issue, corporation law issue. The best environmental lawyers are the best lawyers. This is a case which is just a fed courts question, implications for raw protection. It's a question whether or not, if you seek to remove from state court to federal court on several grounds, one of which is you claim you're a federal officer because you have a federal lease, and the district court denies your removal, whether you can appeal only on the federal officer removal grounds, or you can appeal on all the grounds you were denied. Because normally you can appeal just on the federal officer, everything else you're not allowed to do. But it's not, there's a little ambiguity in the statute. So Vic Shear, who's the lawyer for the environmental plaintiffs in most of these cases, he's going to become a federal courts lawyer for his argument in the Supreme Court in February. It's just a federal court. It's an interesting issue of federal courts. But what's great about it, Jonathan, is there's no political salience to it. The justices, when they approach that, are not going to think this is a climate change case. It's a federal courts question. They'll pay no attention to the practical implications of this on climate change litigation.
And given the current court, is that good or bad for the environmental advocates?
I think it's good. I think they've got the better. I mean, I haven't studied everything, but I read the briefs quickly. I think they've got the better textual argument than the other side. In which case, if I'm right about that, that's good for them, because text is going to be paramount.
Because a claim that I've made, which is that in a lot of these cases, as you've already pointed out, the justices' commitments are to their doctrinal commitments, text, preemption, federalism, what have you. The one area where I think that might be different is environmental issues that relate to small landowners. So, you see the first portion of Justice Scalia's Rapanos opinion talking about the burdens of environmental regulation, the Sackett opinion, that there it seems that the subject matter energizes at least a few of the more conservative justices, whereas most other environmental cases, it could be a tax case. It could be
you're right. There'll be a skewing that way, and also related to that, to the extent that Congress has stopped passing any new environmental laws, since 1990. Last time they passed a really new Clean Air Act, Clean Water Act was like 87 or so. Dangerous species 73. An administration trying to do ambitious things is doing it with old language. And it's not always a neat fit to get that old language to do it. And this is a court which is going to be wary of agencies doing ambitious, far-reaching things with language that doesn't seem to be a neat fit. Not because they're anti-environmental, because their cross-cutting issue is they like to see agencies who have clear authority to do big things. So that may hobble, assuming the Biden administration comes in, as I hope they do. That may make it a little bit harder for them to do some of the things they want to do. Not impossible, but they're going to have to work hard, or they get new legislation. Let me give you one counterexample, though, which could be a sleeper here. And that is another big issue involving landowners in the environmental context is a regulatory taking issue. Very important for people worried that environmental statutes go too far. But as Bob Bork would tell you if he were alive today, the regulatory takings doctrine has a limited at best relationship to the original meaning of the Just Compensation Clause. He made it quite clear he didn't think you really could justify it based on the original meaning of the Just Compensation Clause. And just recently, in a case called Murphy, Wisconsin, Justice Thomas, in a separate dissent, said he doubted whether or not you could justify it based on the original meaning of the Just Compensation Clause. And Justice Barrett might feel the same way. So we could see an resurgence of the power of originalism on the Supreme Court, ironically, a retreat on the regulatory takings doctrine.
You mentioned the challenges that if there is a Biden administration that they will face. If in light of this decision, what's happened since Massachusetts versus EPA, if you were giving advice to the next administration, would you say try and redo the Clean Power Plan, start from scratch, go to Congress, something else?
I would say, one, if you got the Senate, let's get national legislation. I mean, the fact is, the best way to make really meaningful transformative laws which take everything into account, all stakeholders' interests on all sides, is legislation. It's not an agency rulemaking. So you should try to get legislation, and you should do it in the first year. If you can't, then with the current court, I would suggest that you rethink the focus of the Clean Power Plan. I think a lot can be done if you do it. I think you can focus on the facility. I think there are ways to focus on facilities and not just on the grid in the first instance. You can achieve much of what the Clean Power Plan achieves in a more legally defensible way with this court.
And what about what is it, Section 115 for the Clean Air Act lawyers that are on the call? Is that viable, or is that just the fantasy of academics that see it as a powerful tool?
In all due deference to my colleagues in the academy, for purposes of this talk, I will plead the Fifth Amendment.
Well, fair enough. Well, we are at the bottom of the hour. Thank you so much, Richard. There are still lots of questions in the queue. If we had more time, I know we could go on and on. I encourage folks to buy the book. It's my own views. Richard's done a really great job of unpacking the process, the politics. I mean, he hinted at it in his talk, and the politics of the brief writing of who argues, how you argue, the different strategic choices. It's rare in the context of administrative law that we get an account that gives that sort of detail. And I certainly try and tell my students, until you've seen it, it's hard to understand those dynamics. And this is certainly the first book that I can think of that really gives that sort of view of the sorts of decisions that get made, and it's valuable for that alone.
It's hard to make administrative law exciting, right, Jonathan? But it does it.
That's what my family keeps telling me. I think it's incredibly exciting, but at the kitchen table, that doesn't go over that well. In a moment, I will put up the slide with the CLE activity code. The link for both the book at both Amazon and the Harvard University Press website are in the chat, as is the link for the evaluation form. Thank you all again for attending. We look forward to seeing you at future webinar programs that we put on here in the law school. And of course, we very eagerly look forward to being able to host you here at the law school again in the not too distant future. But please join me in thanking Richard for what was a great talk, really, really informative and engaging, and hope to be able to have him in the building for his next book.
That'd be great.
Thank you very much.
Thanks a lot. Thanks, Jonathan. Thanks, everybody. It was a pleasure.